Hello guys, welcome back for another lecture on the subject matter law enforcement, operation, and planning with crime mapping. For today's topic, we will be discussing the Rule 13 of the PNP Operational Manual. That would be the rule on the conduct of arrests. So without further ado, let's proceed to our discussion. Arrest is a very important topic, especially in the field of criminology and especially in the field of law enforcement operations, since all of the reactive operation being conducted by the law enforcement organization is usually starts with the conduct of arrest. And also on the criminal justice system of the Philippines, arrest is the start of the functioning of the remaining pillar. So the conduct of arrest, especially if it is done properly, is very important in the field of criminal justice, in administering justice to the victim, to the offender, and to the community itself. And it is also considered as the fundamental functions of the law enforcement organization. Okay, so let us first define what arrest means based on the definition provided by the rules of court. Okay, so arrest is defined as the legal taking of person in custody in order that he may bound to answer for the commission of an offense. The significance of arrest, as I have stated, not only in law enforcement operation but in other subject matters also, like the criminal justice system, the investigation, the fundamentals of investigation, and the other relative subject, is very significant that most of the activities or processes that the other subject will be dealing or talking about always start with the conduct of arrest. Like, for example, the administration of justice, it will always start with the conduct of arrest. Investigation process, later on, it will fall on to the conduct of arrest. So this specific topic does not only cover the subject law enforcement operation, but it can be also tackled in other subject in the field of criminology, especially when we are dealing with the legalities and technicalities of matters such as investigation and relative issues. Okay? Now, as we defined, arrest is the legal taking of person in custody, meaning that a certain person accused of a certain crime will be taken into custody by the law enforcer. So in the conduct of arrest, it must be noted that it shall be conducted within the legal parameters only. There are a lot of technical issues that we're going to deal with, especially in the conduct of arrest. If there is a problem with regards to the conduct of arrest, then all of the effort of the investigator as well as the prosecutor and the whole criminal justice system itself will already be problematic. So the conduct of arrest must be properly conducted. Now, it is always being asked, when does the conduct of arrest may be considered as legal? Okay? So before we proceed to that, let us first discuss the two classifications of arrest. There are at least two classifications of arrest based on the manner on how it was conducted. So the first classification is we have the regular arrest. So when we talk about the regular arrest, this is the type of arrest that is conducted by virtue of a valid warrant of arrest. So as a general rule, all arrests must be conducted by virtue or with the benefit of a valid warrant of arrest. If it is conducted without the benefit of a valid warrant of arrest, then that would be very much problematic. However, there is an exemption to that issue. So we will proceed to the second classification of arrest, which is the warrantless arrest, or some say also this is the citizen's arrest. The warrantless arrest, by the term itself, meaning that the conduct of arrest will be done without the benefit of a valid warrant of arrest. What are the instances wherein warrantless arrest will be recognized by law and by our legal system. So we will be talking about those exemption later on. So I'm just pointing out that there are two classification of arrest, and that is the regular arrest, and the second one is the warrantless or citizens arrest. Okay? So now we are going to talk about the general guidelines of conducting arrests. The question that we are going to be answering first is the question, when arrest is allowed. Arrest is allowed when a valid warrant of arrest was issued by a competent authority. So when we talk about a competent authority, it must be issued by a judge of a certain trial court. If the arrest was conducted with the benefit of a warrant of arrest, then that is legal and that is legally acceptable. So to answer the question, an arrest may be conducted or may be done if there is a valid warrant of arrest issued by a competent authority. However, as I mentioned earlier, there are instances wherein an arrest may be conducted without the benefit of a warrant of arrest. So there are instances wherein the warrant of arrest is no longer required as long as the circumstances will fall onto the acceptable circumstances enumerated by our rules of court. So when an arrest is being conducted, there are also limitations with regards to the force that must be applied to the person whom you are arresting. So what is the limitation for that? We made mention of this already in the previous lecture that we had, that in every operation that the police officer, police organization will be conducting, it must always be observed that whatever force will be applied in those operations, they must always make sure that violence or form of any excessive force will be used. So the same thing as the conduct of arrest. In the conduct of arrest, we must always remember that violence is strictly prohibited. When there is a need for us to use force, it must be a reasonable force only. So that is the limitation. No unnecessary violence shall be entertained in the conduct of arrest. So if a force is needed, because there are instances wherein a person will be arrested, he will be showing some incooperation. So those are the instances wherein there is a need for us to use force. But remember that the force needed shall always be necessary force and never use violence or excessive force in the conduct of arrest. Okay, so let's proceed to the question, when to do an arrest. So the question with regards to when should a law enforcer conduct an arrest, as answered by the PNP operational procedure, an arrest shall be conducted in any day of the week, at any time of day and night. So there is no specific time or hours in conducting an arrest. So whenever it is ideal to ensure the success of the conduct of arrest or success in serving the warrant of arrest, then it must be conducted. Regardless if it's middle of the night, during Sundays, or even holidays, there's no specific hour or day in conducting an arrest, as long as the success of the operation will benefit, then a law enforcer serving a warrant of arrest is allowed to conduct arrest. So regardless of what time, what date, or what hour it is, the success of the operation is the priority and not the day or not the time or any other matters. Okay? So there is no specific time in conducting an arrest. It is allowed as long as there is a warrant of arrest in any day, in any time, or in any period, as long as its success is guaranteed. Now let's proceed to the question, who issues warrant of arrest? So under the rules of court, it provides there that it is only the judge who can issue a valid warrant of arrest. So it's very plain. Not the mayor, not the governor, or not anyone else. It is only the judge of a trial court who can issue a valid warrant of arrest. So if the warrant of arrest was issued in the name of somebody else and not the judge, then definitely we can consider the warrant of arrest as invalid or void warrant of arrest. Therefore, if an arrest was made by virtue of an invalid or void warrant of arrest, then most likely technicalities will be cited when it comes to court presentation, and there's a likelihood that, of course, the case will be heard or will face dismissal because of this misconduct that was conducted. As I've stated, the conduct of arrest is a very crucial part on administering justice to the person to whom it may due. So it is very much important that an arrest shall be made in consideration of the legal mandates of our law. Okay? So that answers the question, who issues warrant of arrest? It is only the judge of a trial court who is authorized to issue such warrant of arrest. And however, there are exemption also to this. There are some individuals, especially if they're holding such an office, that they are allowed to issue warrant of arrest. So our law also provides some exemption to this, and if only it will fall onto those exemption that a certain person may be allowed to issue a warrant of arrest. But generally speaking, it is only the judge who can issue a valid warrant of arrest. Okay, we have here the question, does a detainee needs to be arrested with a warrant of arrest? A detainee. We're talking about a detainee. A detainee need not to be arrested already by virtue of a valid warrant of arrest. Of course, because he is already under detention, meaning he was already either legally arrested or legally detained. So what should be issued upon him is a valid commitment order coming from a judge in order to justify his detention in a certain facility. So when a person is already a detainee, then he need not to be arrested already by virtue of a valid warrant of arrest, but a commitment order shall be issued upon him by a competent authority, or specifically by the judge who has jurisdiction over the person or his case. Okay, you might want to ask also, are there individuals who are immune to arrest? If you can remember the case of Trillanes before, when he was supposed to be arrested inside the house of the Senate. However, Senate President by then Tito Soto protected Senator Trillanes from being arrested by letting him stay or detaining the senator inside the House of Senate. Those are the instances wherein some individual may be or may not be arrested regardless if they had committed a crime. So when we talk about the persons who has immunity to arrest, they are those senators or members of the House of Representatives while the Congress is still in session. And at that time, the Congress is still in session. The Senate was still in session. That's why Senator Trillanes was not arrested because of his immunity provided by our law from being arrested for his crime before. But of course, the only catch to this immunity is that the Senate or the Congress must still be in session, and with that, they will have the immunity for arrest in cases only that the punishment or penalty shall not exceed 6 years of imprisonment. So if they are accused of committing a crime already which is punishable by a penalty of imprisonment of exceeding 6 years, then that immunity will be already voided. So they will be already arrested by virtue of a valid warrant of arrest. Other individuals that has immunity to arrest are those diplomatic agents in our country. So those are the diplomats that are visiting our country or working as a diplomats for other countries. So whenever they committed a crime that is punishable by not exceeding 6 years of imprisonment, then they have also the immunity to arrest. Okay, so those are some of the individuals who has immunity to arrest as provided by the PNP Operational Manual Rule 13. As I have mentioned a while ago, that we will be defining also what is warrant of arrest. As we discussed, an arrest may be conducted only with the benefit of a valid warrant of arrest. So what is really a warrant of arrest? So warrant of arrest is defined as an order in writing issued in the name of the people of Philippines signed by a judge commanding a police officer to arrest a person or take a person into custody in order that he may be bound to answer for the commission of an offense. So we're going to discuss the concept of warrant of arrest as it was defined legally. As we discussed already with regards to the authority of the issuance of warrant of arrest, as the definition itself also provided that a warrant of arrest shall be issued in the name of the people of the Philippines and must be signed by a judge. And this writing is an order to a certain police officer requiring the same officer to effect this document by taking the person whose name appears on the warrant of arrest into custody, that he may be bound to answer for the commission of an offense, which usually a product of a complaint filed to the court. So that is the concept of warrant of arrest. So basically, before a warrant of arrest must be issued, there must be a sufficient proof, evidence that a crime actually exists. And the law enforcer must convince the judge that there is indeed a crime that was committed and the person whom to be arrested is probably guilty of committing the crime. So without those circumstances, a warrant of arrest shall not be issued. Actually, there's more discussion on the legalities and technicalities of the issuance of warrant of arrest, but in my capacity, I cannot discuss the legality because I think the discussion with regards to the technicalities and legalities of this shall be best discussed on your law subject. So what I'm discussing only is the brief concept of warrant of arrest. So now let's talk about the validity of warrant of arrest. There are a lot of discussion that are always being tackled with regards to the validity of warrant of arrest. Basically, warrant of arrest is valid for a lifetime, or it is valid until if it is revoked or served. So meaning, a warrant of arrest shall remain valid until the time that it was already served, meaning the person was already arrested, or the court had ordered its revocation and the arrest was already invalidated. So those are the instances wherein a warrant of arrest will expire. But generally, a warrant of arrest shall remain valid until, as I've stated, until it was revoked or it is served. The 10-day rule with regards to the warrant of arrest, that is, sometimes it is confusing on others. This 10-day rule refers to the period wherein the court mandates the law enforcer to effect the warrant of arrest. So the court orders the law enforcer to effect the warrant of arrest within the period of 10 days. If the arrest was not made due to many reasons, either the person was no longer in the place where the warrant of arrest was addressed, or the person can no longer be found. So if those happen, the law enforcer who was mandated by the court to effect the arrest shall make a report to the court why the arrest was not made. However, the warrant of arrest shall still remain valid until the two circumstances I discussed, until it was served and revoked. So when the court finds out that the warrant of arrest was not served, then the law enforcer is required to make a report and explain why did that happen. But it will not affect the validity of the warrant of arrest. It will still remain valid until it will be served or until it will be revoked. Okay? So that's with regards to the validity of a warrant of arrest. Its validity is lifetime. The next topic is a very interesting topic indeed. So we are going to discuss the instances wherein an arrest may be conducted without the benefit of a warrant of arrest. The question is, when can an arrest be done without the benefit of a warrant of arrest? And also, the question relative to this is, when can a peace officer or even a private person may be allowed to arrest somebody without the benefit of a warrant of arrest? I would like to point out that with regards to the authority in conducting arrest, it shall be the law enforcer who are designated or who are provided the authority to do so. In no instances that any other person may be allowed to conduct an arrest, because that can be already a violation of the constitutional rights and with regards to the laws that we have in our country. But there are only instances wherein a private person, meaning a person who is not designated by the law to effect an arrest, may be allowed to conduct or to do an arrest. So that will fall under the second classification of arrest, and that is the citizen's arrest or the warrantless arrest. But again, the question still remains, in what instances this classification of arrest shall be allowed? So those will be the circumstances that we will be discussing. The first circumstances wherein a police officer or a private person may be allowed to effect an arrest without the benefit of a warrant of arrest is when in his presence a person is committing or attempting to commit or had just committed a crime. So when in your presence some person had committed a crime or is committing a crime or he is attempting to commit a certain crime, then even without the benefit of a valid warrant of arrest, you are allowed to arrest that person. Regardless if you are a police officer or a private person. So I hope that's very clear that when a person is committing a crime in your face or had committed a crime in your presence or is attempting to commit a crime in your presence, you are allowed to arrest that person regardless if you have the authority to do so or you have a valid warrant of arrest. That is the second type of arrest that I mentioned, warrantless arrest or citizen's arrest. Second, instances wherein a valid warrantless arrest is acknowledged. When a crime has been committed and the person has a reasonable belief that the person to be arrested was the person who committed the crime, then even without the valid warrant of arrest or without the legal authority provided by the law to the law enforcer, a person may allow or may arrest the person suspected of committing the crime. As long as, of course, the two circumstances that we discussed, there is a crime that was committed and you have a probable belief that the same person was indeed the person who had committed the crime. So this is personal knowledge of the person, not by hearsay. that maybe somebody would be pointing out that this person had committed a crime, please arrest him. If you don't have any personal knowledge regarding that case, regarding the incident, then I think that would be the cause of invalidation of the arrest. So that probable cause or belief must be a product of a personal knowledge of the same person who will be affecting the arrest of that person. So I hope that's clear. Third, instances wherein an arrest may be conducted without the benefit of a warrant of arrest is when the person to be arrested is a person who escaped from prison or detention facilities. So those individuals who escaped from prison or detention facility had been already arrested by virtue of valid arrest or valid warrant of arrest. So if they escape, there is no longer a need for another warrant of arrest to be secured before you arrest those persons. So if you know them to be a prison escapee or a detention escapee, you are allowed, regardless of your authority, if you're a private individual or a law enforcer, to arrest those individuals without the benefit of a valid warrant of arrest. And the fourth circumstances is when the person to be arrested was released on bail and he tries to leave the country without permission, then he may be arrested without the benefit of a warrant of arrest. And the fifth instances is when the person to be arrested had violated a condition of his probation, which still can be considered as an evasion of sentence, and that is similar to the third circumstances that I discussed. So you are allowed to arrest that person without the benefit of a valid warrant of arrest. And the sixth instances wherein a valid warrantless arrest may be done is when the person to be arrested had been adjudged by the immigration commissioner as an undesirable alien or person, then there is already a mandate for him to leave the country by virtue of a valid deportation order, but he did not obey such order given to him, then anybody without valid warrant of arrest may be allowed to arrest that person and bring him to the custody of the law. Okay? So that ends the part 1 of this lecture. If you have questions relative to what we discussed so far, kindly type them on the comment section and I will try to get back to you soon. So we will be uploading also the second part of this lecture immediately. And I do hope you learned something from this lecture. That's it for today. See you on the next video.